Hello everyone, welcome to Times Trial. This is Advocate Preeti Acharji, and today in the morning I have uploaded the first part of Module 2, that is Jurisdiction of Criminal Code Inquiry and Trial. Now I'll upload the second part where I'll be dealing with the other two topics, that is complaint before the magistrate and also inquiry proceeding before the magistrate. So these two topics will be dealt in this part of the video. So the first part is complaint to magistrate under section 223 to 226. Now let's quickly see the synopsis. So in the synopsis, you can start with an introduction, then complaint before a magistrate, a preliminary gateway to justice, then object and scope of the provision, starting from section 223 examination of complaint, section 224 postpone of issue of process, section 225 dismissal of complaint, section 226 procedure where magistrate is not competent. Fourth is significance and importance of the procedure, and fifth is conclusion. Now to start with the introduction, you can start with how the procedural framework relating to complaint before a magistrate becomes a critical component in the criminal justice, and how this provision led the methodological process that ensure a complaint is scrutinized, verified, and acted upon only after the satisfaction of basic legal standards, and how this provision reflects the principle that mere allegation should not automatically result in prosecution and provide safeguard for both the complainant and the accused. Now let's talk about complaint before a magistrate, a preliminary gateway to justice. So filing a complaint before a magistrate is a pivotal role in initiating the criminal justice process, especially in cases where police may not have acted upon the information or where the offense is non-cognizable in nature. So this complaint to magistrate can be filed in two situations, where especially in cases where the police have refused to register your FIR or where the offenses are of non-cognizable nature. So what is a non-cognizable offense? So under the BNSS, under section 2 subsection G, it defines cognizable offenses, which means those offenses for which cognizant case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. So these are those kind of offenses where the police are given the power to make arrest without any sort of warrant. So this kind of offenses will be like the serious offenses like murder, rape, or cheating. This kind of serious offenses are considered under cognizable offenses, where the police officer can register the FIR and make arrest without the warrant. Now, to the opposite will be the non-cognizable offenses, where the police has to take the magistrate consent and can make arrest only with a warrant. Now, this part also empowers the aggrieved person to directly approach the judiciary seeking redressal, now ensuring accessibility to justice even in circumstances where the executive machinery is unresponsive. It also reflects the principle that the door of justice remain open to every citizen, enforcing the idea of participating justice and accountability. It includes the examining the complainant, then postponing the issue of process to allow investigation or inquiry, dismissing the complaint if no sufficient ground are found, or transferring the case if the magistrate lacks jurisdiction. Now, these steps aims to strike a balance between the right of the complainant and the need to prevent frivolous litigation. Now let's quickly see the objective of these provisions. So this provision provides an avenue for individual to seek justice by directly approaching magistrate, especially in cases where the police action is unavailable and inadequate. It also lays down fair and balanced procedure that filters out frivolous and malicious complaint at a preliminary stage. It also protects the right of the accused from being unduly harassed by ensuring judicial scrutiny before process is issued. Also empowers magistrate with discretion and procedural tools to deal with complaints judicially. It lastly maintains the public confidence in the judicial system by ensuring accessibility and responsive to graveness. Now we can see the scope. So these are applicable to all complaint filed by a magistrate relating to offences under the BNS.
covers preliminary examination, inquiry, dismissal of complaint, or commencement of proceeding. Applies where the magistrate take cognizance of an offence, especially when the case is not taken up by the police or in non-cognizable nature offences. Also ensures structured procedural safeguard that balance individual rights and judicial efficiency, provides scope for judicial intervention before process is issued or trial commence, preventing abuse of the criminal justice system. So now we'll start with section 223 that talks about examination of complaint, which was previously section 200 of CRPC. Now this section says, as per subsection 1, that when a magistrate receives a complaint and decide to take cognizance of the offense, then at first he must examine and ask question to the complainant, and if there are any witness, then they have to ask question to them as well, and this must be done under the oath. Their statement must be written down and signed by the complainant, the witness, and the magistrate. So there's a provision which says that important safeguard for the accused. Now, the magistrate must not take cognizance of the offense without the first giving the accused a chance to be heard. Now, this ensured that fairness and the accused's right to be heard before the magistrate are proceeded. Now, the provision number 2 is when examination is not required. Now, as in the subsection 1, we have seen that there must be an examination of the complainant and as well as the witnesses. So, under this provision, we'll see the condition under which the examination is not required. The first is that the complaint is made in writing by a public servant acting in their official capacity, or the complaint is made by the court. B. That the magistrate has transferred the case to another magistrate under section 212. So, under such condition, the examination is not required as prescribed under subsection 1 of 223. Now, proviso 3 is that no re-examination if already done. Now, suppose if the first magistrate has already examined the complainant and the witnesses, then transfer the case under section 212, and if a new magistrate is appointed, then he doesn't have to repeat the examination again. So under the BNSS, there is a new subsection that has been added in this provision, that is subsection 2 of section 223, which talks about special protection for public servant. Now suppose if a complaint is made against a public servant for something they did while doing their official duty, then the magistrate is entitled to take cognizance unless their public servant is given a chance to explain the situation. B. A report is received from the public servant superior officer explaining the fact and circumstances of the incident. Now let's see section 224 that talks about procedure by magistrate not competent to take cognizance of cases, which was also previously known as section 201 in the previous CRPC. So let's see what does the section says. So if a complaint is made to a magistrate who does not have the authority or the jurisdiction or the power to take up the case, then the magistrate must do the following based on how the complaint was made. Now, in clause A of the section, suppose if the complaint was made in writing, then the magistrate must return the written complaint to the complainant with a note or endorsement saying that it should be submitted to the corrected court. B. If the complaint is oral, then the magistrate should direct or guide the complainant to go to the appropriate court. Now, section 225, postponement of issue of process, which is also previously known as section 202 of the old CRPC. Now, the section says that when a magistrate receives a complaint that they are allowed to handle or that has been assigned to them under section 212, they can delay issuing summon to the accused and do further inquiry or investigation first. Now, this section also includes subsection 1, which says that the magistrate may choose to delay issue processing like summon and inquiry into the case themselves, or order an investigation by a police officer or someone else they trust. Now, the mandatory delay, that if the accused live outside the magistrate jurisdiction, then the magistrate must postpone issuing processes. Now, the purpose of delay, to decide whether there is enough reason to proceed with the case. Now, there are proviso which says that the magistrate cannot order an investigation if it is found that the offense is one that can only be tried by the court of session. B. That the complaint was not filed by a court and the complaint and witnesses have not been examined on oath under. Now, subsection 2 that talks about during this inquiry stage, the magistrate may take witness evidences on oath if they think it is needed. Now, there is a proviso to this subsection that if the case is triable only by the court of session, then the magistrate must ask the complainant to bring all the witnesses and examine them on oath. Now, subsection 3, it talks about if someone other than a police officer is asked to investigate, they will have all the power of the police officer as per the BNSS, except they cannot arrest without a warrant. Now, section 226 that talks about dismissal of complaint, which was also previously known as section 203 of the old CRPC. So let's see what does the section says. Now, if the magistrate has heard the statement of the complainant and witnesses on oath, if any, as per section 223, and has reviewed the finding of an inquiry or investigation done under 225, feels that there is no sufficient ground left to move forward with the case, then the magistrate must dismiss the complaint. In every such cases, the magistrate must also briefly record the. So now let's see some common case law under these provisions. Now the first is Chandra Deo Singh versus Prokesh Chandra Bose and another, where it was established that the magistrate must thoroughly examine the complaint under this old CRPC section 203, which is also currently the, and it was also specified that any record clearly reason if dismissing it. Now, a suspect is not entitled to a hearing at the revision stage unless process is being issued. So, this was the first case that you can write and remember some lines upon it and could shortly brief out the case. Then there is Manohar Bhai, Muji Bhai Kakaria versus Salish Bhai, Mano Bhai Patel, and others. Here, an accused has the right to be heard in a revision against dismissal of a complaint under section 203 of old CRPC, which is current. So now the last case will deal with Anam Charan Behre versus State, where the magistrate has the duty to scrutinize complaint with due diligence before proceeding. A mechanical or superficial approach in impossible under criminal law was established. So these are some of the previous cases, but are important to this provision are highlighted. These cases are based upon the old CRPC, but as there are no such specific establishment in the current law in these provisions, except one or two. So you can cite these cases correctively in answer paper. Now we'll see the importance. So these provisions prevent misuse of judicial machinery, as it established a filtering mechanism to avoid baseless or malicious complaint from burdening the court and harassing the accused. Second, it uphold natural justice as preliminary examination and inquiry before taking cognition, thereby protecting the right of both the complainant and the accused. It also strengthens judicial discretion. It allows magistrate to exercise reasoned discretion in processing with complaint, reflecting independency of the judiciary. It also ensures procedure continuity and provides a mechanism for transferring case of jurisdictional or other limitation of the magistrate. Now you can end with a conclusion, that is that specifically can state about that this section 223 to 226 of BNSS reflect a balanced approach in handling criminal complaint. It provides the crucial safeguard against the arbitrary issuance of process while simultaneously ensuring the genuine grievances are addressed and how the complaint should be addressed, and also that the accused has the right to be heard are all specified under these provisions. This question, it will most probably be come under 10 marks, or else it will come as a short note. So this will be 27 to 2. Now let's proceed with inquiry provision before magistrate from section 227 to 232. Now, let's quickly see the synopsis. So, the first is introduction, then the object of inquiry proceeding, provision related to inquiry proceedings, that is starting from section 227 to 232, and then principle underlining the provisions, role and discretion of magistrate under inquiry, practical importance in criminal justice process, and then conclusion. Now, to start with the introduction, now this inquiry stage under the BNSS is a crucial procedural step designed to assess whether sufficient ground exists to proceed with the trial. It governs how a magistrate should act once a complaint is filed or a police report is submitted, and also that this stage protects individual from baseless accusations and ensure that only genuine cases proceed further in the. Now let's quickly see the objective of the inquiry proceeding. These are followed to prevent harassment of innocent person through false or frivolous complaint, ensure only prima facie genuine cases are committed for trial, evaluate whether there is enough material to summon the accused, filter out weak or legally untenable cases at any early stage, uphold the accused's right to a fair trial by prosecution. So, to start with, Section 227, issue of process, which was previously Section 204 from old CRPC. This section deals with the issuance of summons or warrants by the magistrate after taking cognizance of an offence and being satisfied that there is a sufficient ground to proceed against the accused. Now, subsection 1 says that when process is to be issued, now, if the magistrate is of the opinion that there is a sufficient ground to process and that case appears to be a summon case, which means that magistrate shall issue summon to the case. Warrant case, which means that the magistrate may issue a warrant or summon depending on the situation to secure the presence of the accused before himself if he has a jurisdiction, or before another magistrate who has jurisdiction. Now, the proviso is that the summon or warrant can also be issued electronically. Now, subsection 2, it talks about the condition for issuing processes. No summons or warrant shall be issued unless the prosecution has filed a list of witnesses. Subsection 3 talks about copy of the complaint to accompany processes. In case institute can on a written complaint, each summon or warrant must be accompanied by a copy of the complaint. Subsection 4, requirement of process fee. If the law requires payment of process fee, then no process shall be issued unless the fees are paid. Then subsection 5, non-derogation clause, which says that nothing in this section will affect the provision of section 90 that deals with issuing processes to compel appearances. Now, this ensures that section 227 does not override or conflict with any power. Now, section 228, which talks about magistrate may dispense with personal attendance of the accused, which was previously section 205 of the old CRPC. This provides that the magistrate has a discretion to allow the accused to appear through a lawyer instead of appearing in person during certain stage of proceeding, especially in summon cases. So the first subsection is exemption from personal appearance. When the summon has been issued to the accused, the magistrate may allow the accused to appear through his advocate instead of personally attending, and this exemption can be granted if the magistrate find valid reason to do so. For example, if the offense is minor or the accused lives far away, then this kind of exemption can be given. Now, the key points are that this is meant to ease the burden on the accused in less serious cases and prevent unnecessary inconveniences. Now, subsection 2, it talks about magistrate right to call for personal presence. If the magistrate initially allows the accused to appear via advocate, he can later require the personal presence of the accused at any stage of the proceeding. And now, if the accused fails to appear when directed by the magistrate, then the magistrate can enforce his attendance by issuing the procedure already provided under the law, that is, issuance of warrant. Now, the key points are that this ensures that the accused cannot misuse the permission and must appear when. Now, Section 229, which talks about special summon in case of petty offences, which was previously Section 206 from old CRPC. This talks about that to expedite the legal process in cases involving minor offences where the fine is up to 5,000 involved, then it allows the accused to plead guilty without appearing in court under certain safeguards. Now, the subsection 1, mode of special summons for petty offences. Now, if the magistrate believes that the case can be summarily disposed of under section 283 or 284, that is the summary trial provisions, then the magistrate shall issue a special summon requiring the accused to either appear personally or through an advocate before the magistrate on a specified date. Now, plead guilty is should be in writing and send it by the post messenger along with the fine amount, or authorized his advocate to plead guilty and pay the fine on his behalf. Now, the important condition is that the maximum fine that can be demanded in the special summon cannot exceed rupees 5,000. Exception is that if the magistrate thinks summary disposable is not proper. Now, subsection 2 that defines the term petty offences. Now, this petty offences under this section can be defined that any offences which are punishable only with fine not exceeding rupees 5,000. It does not include offences under the Motor Vehicles Act, and also the offence under any other law where conviction in the absence of the accused is allowed. Now, subsection 3 is empowerment of magistrate. The state government can empower any magistrate to exercise the power under this section for offences that are compoundable under section 359 or punishable with imprisonment up to 3 months or fine or both if the magistrate believe imposition of fine alone will suffice for justice. Now, section 230 that talks about supply to accused the copy of police report and other document, which was previously section 207 of old CRPC. This says that the magistrate must without delay and at least within 14 days from the date the accused appear or is brought before and the victim 3 copies of the following documents to be supplied. First, the police report, the FIR recorded under section 173, and the statement of the witnesses recorded under section 180 subsection 3 that the prosecution plans to present in court, excluding any part of the police officer has asked to keep confidential under section 193 subsection 7, that is any confession or statement recorded under section 183 or any other document or important part of it sent with the police. Now, the proviso is a special clause or exception. The first proviso is that if a part of the statement under clause 3 is excluded by the police officer, the magistrate will review that first and the reason for exclusion, and any may still order a copy of that part to be given to the accused. Now, the second proviso is that if the magistrate finds that any document is too long or bulky, then instead of giving a physical copy to the accused or victim, he may give the copy electronically or allow inspection of the documents in court either by the accused or their lawyer. The third proviso is if the documents are provided in electronic form, it will be delivered. Section 231 that talks about supply of copies of statement and documents to accused in other cases triable by the Court of Session. That is similar to section 208 from old CRPC. Now, if a case has been started without a police report, like through a private complaint, the magistrate must issue process under section 227. It seems that the offence is one that can only be tried by the Court of Session, that the magistrate must immediately give the accused free copies of the following document. Firstly, all statement of people examined by the magistrate under section 223 or 225, any statement or confession made under section 180 or 183, any document that the prosecution has produced before the magistrate. Then It also includes proviso. The first proviso is that if the magistrate believes that any document is too lengthy or voluminous, now instead of giving the physical copy of the accused, the magistrate may allow the accused on their advocate to inspect the document in the court. And second proviso is if the documents are given to the accused in electronic format, it will be treated as if they were properly and officially being supplied. Now, this last two proviso is also repeated in section 230. The second and third proviso of section 2. Now we'll talk about section 232, that is sending case to session court when the offense is exclusively triable by it, which is also similar to section 209 from old CRPC. Now, if a case comes before the magistrate and it is clear that the offense must be tried only by the session court, the magistrate shall take steps followingly that after following the processes under section 230, like for police report cases or 231 for other cases, he may send the case to the court of session and keep the accused in custody unless bail is granted until the case is committed. B. As per the rules of the Sanhita, he must keep the accused in custody until the end of the trial in the court of session. Send to the session court the case record, all documents and articles that are to be used as evidences. D is inform the public prosecutor about the case being committed to the section court. Now, the proviso here is the first proviso that all step under the section must be done within 90 days from the date the magistrate take cognizance of the offense, and it can extend this time by maximum to 180 days, but must record proper reason in writing for such sort of extension. The second proviso is that if the accused, the victim, or someone authorized by them files an application before the magistrate, that application must be forwarded to the court of session along with the committal of the cases. Now, the principle underlying the provision are simple, the general principles like principle of natural justice, presumption of innocence, judicial mind, fairness, and equity, judicial economy. So these are some of the principles that guide these provisions. Then there are role and discretion of magistrate during the inquiry. The first role is that it will assess whether the material on record is sufficient to proceed, direct further investigation, either issue process or dismiss the complaint, examine document and statement supplied under section 288, under section 228, to determine whether the case should be committed to the court of session, to apply judicial discretion without bias or influence. Now, the practical importance of this criminal justice process is that it saves times and prevents closing of court with weak or false cases, reduces mental and financial burden on the accused, help protect public servant from vicious litigation, allow fair opportunity for both parties to present preliminary material, and ensure that serious matters are rightly escalated to higher courts like the court of session. Now, the final is the conclusion where you can specify the same, that how this inquiry proceeding for the magistrates are crucial and how it ensure that not only justice is done but also seen to be done by protecting the right of the accused one, enabling.
So this is all in the second module. Here we have rightly discussed the potential question that can be asked in the question paper, and also further the synopsis of each of the question, that how you can frame your answer, what will be the synopsis that you can include. So you basically focus on the synopsis and remember the order of the synopsis and also the crux of the section. That will be enough for your exam. So if you like this video, then please like, share, and subscribe Timeless Trial so that you don't miss any latest update from our channel. And we'll keep posting the notes on the other subject also, like administrative law, company law, as possible. Thank you.